You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome once again to Ask a Lawyer here on CP24. Good to have you along for this week where we shatter myths about employment law and make you workplace smart. Don't you know, I'm your host, John Scholes, and joining us again this week, my co-host, employment lawyer, Lior Samfiru from EmploymentLawyer.ca. Right off the top, I'm going to tell you how to reach out to Lior on your own time, 1-888-861-4555, ask at EmploymentLawyer.ca. We got a lot of ground to cover over the next 30 minutes. We'll get to some phone calls from one of our radio shows. In fact, you can tune in and encourage to do so and call into the radio show Sundays, 1 p.m. here in the GTA. On News Talk 1010, that's some emails and a bunch of other stuff. Our main topic, by the way, is going to be everything you need to know about severance deadlines. Important stuff every week here on the show. That's coming up in just a bit, but we always start with Lior. Good to have you along again, pal. With the week that was, something that's going on in your end of the court. What do you say?
A lot's going on, Johnny. Great to be here, of course, to talk about employment law, to try to demystify this topic. We all have rights, right? We all have jobs, and those rights sometimes conflict with what our employer thinks we should have or what our employer believes our rights are. Well, by watching the show, you'll know the real truth. You'll know what you're owed if you lose your job. You'll know what to do if you're harassed or bullied in the workplace. You'll know what to do if your job changes, your hours change, if your business is sold, you name it. This is the show where we tackle all these things that are so important. If you work, if you lost your job, if you're in this province wanting to know what the law says, we'll tell you, of course. And to reach out to me beyond the show, if you want to actually connect and discuss your matter privately throughout the show, we'll give you that contact information on your screen, so stay tuned for that. But I always like to start off with a matter that came across my desk just very recently. Well, John, I spoke with a lady that was working as a live-in care provider for an elderly woman. She was a live-in caregiver, and she'd been doing it for about 3 years. Everything was being fine. Well, as very recently, she was notified by the son of the lady that she was caring for that they've decided that her mom should be living on her own because they're moving her to a different place. And they still wanted her to continue, the lady to continue providing care, but she's not going to be able to be a live-in care provider. She's going to have to find her own place and find a way to commute to care for the older lady. Obviously, that's a big deal. They weren't paying her anymore for it. They just said, you're now going to not live there. When she raised the issue, and she also said, by the way, I don't think you're paying me vacation pay properly. They said, you know what, then we're going to just reduce your pay since you're causing us such a headache. Of course, upset, distraught, she called me and she wanted to understand her rights. Well, the first thing I want to say here is this. Live-in care providers, just like everyone else, if you are an employee, you have rights. That also extends to part-time employees. That also extends to seasonal employee. If you are an employee, you have rights. Now, for her, that means that no, her employer could not just decide to take her from being a live-in care provider to now living on her own, for her to have to incur that expense. That's a massive change to the terms of employment. But to make matters worse, she was penalized for trying to ask questions about her rights, about vacation pay. We're going to reduce your pay because you asked those questions. What we call that a reprisal. It's illegal. You cannot be punished, penalized in any way for standing up for your rights or for asking questions about your legal rights. Your employer can never penalize you. So this employer, I call them an employer, they were a family, still, they have the obligations of an employer. And it's an important thing to remember there. You may be working for a small business, an unsophisticated employer. It doesn't matter. The law doesn't distinguish. You still have rights. So I'm going to help this lady pursue a constructive dismissal here, also to pursue additional compensation because of the reprisal. But the real reason I'm bringing this up to you is regardless of the type of job that you have, regardless of the size or sophistication of your employer, you have rights. So if your rights are not being protected, if you're worried that your rights have been infringed somehow, you have to give me a call.
All right, good stuff, Leora. I mentioned off the top the phone calls, which we get from our radio shows. Want to go to our first call for today. Anytime you want to reach out, you can do so. News Talk 1010, Sundays at 1 p.m. And the phone number, as Leora mentioned, 1-888-861-4555. Ask at EmploymentLawyer.ca. Okay, phone call number one, pals, coming up right now.
2 years ago, I got into a accident, and I have doctor's papers backing me and stuff like that. And basically, I'm at the point where financially I have to go back to work. And I was like, so what about going back to work? And they were like, sorry, you no longer have a job here. This was said to me by a secretary. I was a forklift driver in a warehouse, 10 years, 38.
Yeah, well, let's take a bit of a step back here. Because of the fact that if you're coming back from a medical leave, a disability leave, your employer has to make all efforts to bring you back. That doesn't necessarily mean that your job is guaranteed, but what is guaranteed that your employer is going to make all efforts to bring you back, to find the same role or a similar role for you, and even to accommodate you if necessary. So in this situation, if this person's employer said, "No, you just don't have your job back, we're not even going to go through that analysis," well, that's illegal. That's a human rights violation. So right off the bat, I'd want to discuss the issue with him to see, could they have brought you back, or legitimately is there no job for you? So the second issue, of course, is that of severance. Doesn't matter if he was on a leave, doesn't matter if he's a forklift driver, of course he's owed severance. In fact, he's probably going to be owed even more severance if he's still not at optimal health. Well, to show you, or at least give you an idea how much severance he's owed, we're going to go back to our favorite tool, to the severance calculator. You can find that, of course, at pocketemploymentlawyer.ca, completely free, completely anonymous. Let's run the numbers and see what this person is owed. So he's been there for 10 years. He's 38 years of age. We can see on the screen that he's owed right around 10 months of severance. And by the way, that could be even more than that, given the fact that he has a medical issue. So that's how easy it is to use a severance calculator. You should also use it to, if you lost your job, if you're worried about losing your job, check out pocketemploymentlawyer.ca.
All right, good stuff, Leora. Thank you so much. We'll take a short break, and on the other side, everything you need to know about severance offer deadlines. So stick around for that. I'll give you the contact information as we get into a break. 1-888-861-4555. Ask at EmploymentLawyer.ca. We will continue with Ask a Lawyer right here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And welcome back to Ask a Lawyer here on CP24. John Scholes and, of course, employment lawyer Leora Samfiru is joining us again this week. As we always tell you right off the top, into and out of break, we want you to call Leora and his team anytime. It's always good to have that conversation on your own. It's simple, 1-888-861-4555. You can also email if you prefer. That is ask at employmentlawyer.ca. Okay, Leora, main topic. It's that time of the show where we get into this. Everything you need to know about severance offer deadlines. I'll start with an easy one, lob it over the plate for you. How is a typical severance offer structured, pal?
Thanks, John. I appreciate that. So severance offers, even though you may be working in different companies and different people have different jobs, severance offers tend to follow a very similar format. So the first thing a severance offer is going to outline is that you're being let go. It may or may not specify the reason. It's not required to specify the reason. It's going to then outline what you're going to be paid no matter what. And then, of course, it's going to make you an additional offer. In addition to this amount that you're going to get paid right away, we're going to offer you something else. Now, keep in mind, in most cases, that offer is a lot less than what you're actually owed. A lot less. You may not know that, but that's what we're here to tell you. And then at the end, there's going to be a deadline. That deadline would say, this offer that we made you, which, by the way, it's not really a good offer, but let's forget about that for a sec. This offer that we've just made you is only open to acceptance by a certain date, Friday, Tuesday, and that's, of course, where the problems start, and that's what we want to talk about.
Okay, so someone's got a severance package, it's got a deadline. Should they be concerned about it? What if they drop the ball, they don't sign by the time the deadline elapses? Or I mean, why do companies use them in the first place, right?
So let's be very clear here, and I'm not going to mince any words. That severance deadline ultimately is meaningless. It's meaningless. And the reason why it's meaningless is because your legal rights don't expire Friday at 5 o'clock. In fact, your legal rights do not expire for 2 full years. That offer, that severance deadline is a pressure tactic. Your employer may want you to feel that you're going to lose something if you don't sign. So that let's give you a deadline and you're going to be more inclined to sign off on this offer. Understand that that offer is not adequate. So that deadline makes you potentially want to accept it without doing your homework, without doing some research, and without getting advice. And once you accept it, you're kind of stuck with it. Employers use that because they want employees to accept it. It's an effective tool. Out of 10 people that the company lets go, even if all 10 are offered inadequate severance, probably 7 or 8 of them are going to accept that offer because of that severance deadline, because they're going to be stressed out over it. Well, you're now going to know better. You're not going to let that happen to you because you've just heard me say that that deadline is meaningless. Ignore it. Forget about it. Your rights do not expire then.
So we always advise people to seek legal advice, come see you and the firm before they sign anything. What happens if that deadline time elapses? They haven't had time to get legal advice. Can they ask for an extension?
Well, keep in mind, because that deadline is ultimately meaningless, there's no need to ask for another time or an extension because it's meaningless. Now, if you want to be extra polite, and it's never a bad thing to be extra polite, you can let your employer know, just out of courtesy, hey, employer, I'm still taking some time to consider this offer. I'm going to be able to get back to you in a week and 2 weeks. And that's fine. You can do that. You don't have to. Nothing bad happens if you don't do that, but also nothing wrong with it. If you don't do it, do not stress out because, as I said, that deadline ultimately is meaningless.
Again, this week we were talking about everything you need to know about severance offer deadlines. So someone's, they got a severance offer, they panic, right? They sign it right. Maybe they're on the spot, but they send it quickly. And then they realize, maybe I shouldn't have done that. Is there a chance to go back and do something about it?
John, my least favorite calls that I get, and I get those at least once a week, is from someone that signed that severance offer and after the fact realized, holy cow, that was a bad decision. I'm owed a lot more. Maybe I'm owed an extra $75,000. But the problem is that once you've signed that offer, generally speaking, you're stuck. You can't go back to change your mind. You can't go back and ask for more. Even if there was a deadline, even if there was a pressure tactic, even if that offer was horrible, as long as you voluntarily chose to sign it, you're stuck with it. And that's why I say do not, under any circumstances, sign that offer without going into the severance calculator. By the way, you can find that at EmploymentLawyer.ca or without calling me because you have to do that before you sign. Once you sign, that's it. There's no point doing it. And every week I have to tell people the bad news, John, that they're stuck even though they were owed a lot more.
So here's the typical scenario. You've lost your job. You've been given a severance package and offer. It's got a tight deadline, real tight, maybe, Friday at 5 or whatever. What's the process? How do we go down that road to fix it? Or at least make sure we get what we should get, right?
So the first thing someone should do in that situation is take a deep breath, okay? Understand that the world hasn't ended, that everything is going to be fine. And once you do that, you can start a good place to start, as I said, is EmploymentLawyer.ca. Use the severance calculator and get an idea right off the bat, on the spot, whether or not the offer is good or not. And then let's reach out. Reach out to me, my team. Let's have a talk about it. Let's make sure that you understand what the offer means, what it doesn't mean, what you're owed, and then we will negotiate proper severance. Don't worry about that deadline, okay? You're not going to lose out. Think about it this way. If I owed you $100, but I said I'm only going to pay you $30 if you accept by Friday, you wouldn't accept by Friday because I owed you $100. Well, the same thing with that severance offer. Do not accept it. Do the right thing. Let's negotiate proper severance.
Again, if you're here in the GTA, Sundays, 1 p.m., catch us on News Talk 1010 doing our radio show thing, an opportunity for you to call in, ask your questions. It may appear in a future show. Let's get to that second phone call right now, Lior.
I have a booked holiday. It's 1 day. My boss agreed to it. Now he's trying to say that I have to work. Probably proved about a month ago, and the holiday is next Friday. I'm traveling over the border for a concert, which I've already bought tickets for, booked hotel, etc. And I'm just wondering what can be done. Do I have any rights?
So this is something that actually, believe it or not, John, comes up more often than you realize. You get a vacation approved, you're making arrangements, you buy your plane tickets, your hotel is booked, and then your employer says, actually, we're not going to be able to let you go on this vacation because we need you. Well, what happens in that situation, if you got the vacation approved and you relied on that approval, okay? You relied on it to book your vacation. Your employer can't punish you for going on that vacation, even if they tell you, no, don't go. Now, that means that you can't be fired for cause, you can't be suspended. But what your employer is allowed to do, because they're allowed to do this anyway, is they can let you go without cause. That means with severance. So ultimately, nothing can stop your employer from letting you go with severance. They can do that for any reason, but they can't punish you. They can't let you go for cause. So you may have to make a decision. Am I comfortable with the risk of losing my job, even if I get my full severance? But ultimately, yeah, if you've booked that vacation, your employer should not then change his or her mind just because something changed on their end.
All right, good stuff. I want to grab a third phone call, but we'll do it on the other side of the break. Lior, so stick around for that. You as well. Here is the phone call as we get into break. To reach Lior and the team anytime, 1-888-861-4555. Ask at EmploymentLawyer.ca. This is Ask a Lawyer right here on CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer here on CP24. John Scholes and always my co-host, employment lawyer Lior Samfiru. Reach out anytime you would like. Always encouraged to do so. Phone number first, 1-888-861-4555. Email ask at EmploymentLawyer.ca. But you'll catch us across the country on radio, especially here in the GTA. That is Sundays, 1 p.m. News Talk 1010. Lior, as you know, we do that for a complete hour. We get a ton of phone calls, and those phone calls sometime appear on this show, and we talk about them. Phone call number 3 for the evening right now. Lior's coming at you.
Last Wednesday, I received a written notice that my employment will be terminated, and I was escorted from the office. There is no specific cause of the dismissal, rather than the business is very slow. So my question is basically, because I worked for the company from 1998 to now, am I entitled to severance pay? I had a manager position and around 140K.
So this is what we call a classic without cause termination. An employer is allowed to do that as long as proper severance is paid. And it's very important for this person to understand what she is owed, given the fact that we're talking about significant amounts after all these years of service. So yes, severance is owed. Let's go back to pocketemploymentlawyer.ca. We'll use our severance calculator tool to show you how this person and any person can find out how much severance they're owed. So we know that this person's been there for 25 years in a managerial role at the age of 53. We don't know how much severance they were offered, but we do know, you see that on the screen, how much severance they are owed, which is 24 months pay. And that salary, that's $280,000. That's why it's so important to get advice to use the severance calculator tool. You may be shocked at how much you're actually owed.
Lior, I want to get to a question here while we still got some time. It came across email a short time ago to you. Says this: I was just lured away from my job of 18 years for a sales position with a new company. After 3 months of work, I've heard that my new employer is thinking of replacing me already. What are my options?
So obviously this person's employer is allowed to let them go because, as I said earlier, an employer can let you go as long as severance is paid. The thing here is this person worked for 18 years and they were recruited away from a job, from that job to come here. When you're recruited away from a job, only to then be let go, you are owed enhanced severance that, of course, recognizes your past service. So you may have only worked for the company for 3 months, but because you were recruited away, you could be considered to have 18 years of service and could be owed 24 months of severance. So this is reason 2051 why you have to get that legal advice if you lose your job. Again, there may be many reasons and many circumstances that may make it so that you're owed a lot more than you realize.
We'll take a short break, a little bit more to go here, but I'll give you the number as we get into the break and then come right back. For more, 1-888-861-4555 is how you reach out by phone. Ask at EmploymentLawyer.ca and also that website, right, pocketemploymentlawyer.ca. More Ask a Lawyers coming up. This is CP24.
You have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
And Ask a Lawyer here on CP24. To reach out to Lior anytime, which you can do after the show or otherwise, 1-888-861-4555. Email is ask@EmploymentLawyer.ca. As well, Lior, a ton of live streaming you do every week. You want to catch those on Facebook and YouTube. Simply go to stlawyers.ca to contribute to that particular event. Here's a question for today, Lior, for tonight. It says, I was just fired from a manufacturing plant where I worked as a supervisor. I'm not part of a union, but some of the others who were fired are. Can you help all of us get severance pay?
Ask this often, John, and myself or any employment lawyer can only help non-unionized employees with their employment issues, certainly with respect to severance. No lawyer can help a unionized employee. It has to be the union. There's a process outlined in the collective agreement, and only the union is allowed to do that. It's not a choice, it's not an option, it's simply how the law operates. Also, unionized employees have different rights. So a lot of what you hear me talk about on the show here, if not everything you hear me talk about on the show, does not apply to unionized employees. So if you're a unionized employee, your call is to your union. If you're a non-union employee, you lost your job, it's a constructive dismissal, you're being mistreated, bullied, harassed, anything happens to you, that's when you pick up the phone and you give me a call.
All right, we're just about out of time. We've packed in as much as we can, but I will leave you with the contact information as we say goodbye to reach out to Lior. First, that phone number, 1-888-861-4555. It's ask@employmentlawyer.ca. The website, pocketemploymentlawyer.ca, is what you want to use. That gives you free and anonymous access to the severance calculator, which Lior uses every week. And finally, our radio shows, News Talk 1010, Sundays at 1 p.m. in the GTA. And always reach out here for more. CP24.com/ask-a-lawyer. And we'll catch you next time right here.